So what I tried to do is give you a set of materials that you can save and keep and use as reference material, okay? So you've got the lawyer who doesn't understand money, and you got the forensic accountant who doesn't always understand the law because it's unbelievably opaque, all right? And as we've talked about in conference after conference after conference, what is said in the law is not written in terms that CPAs recognize because it's written by people who are not financial people, okay? And that includes our appellate courts, okay? It's just that simple. These are English majors trying to make understanding of specific terms. Take, I don't know how many conferences we spent talking about goodwill and the different terms used in forensic accounting for goodwill versus what's written in cases, because those terms do not match up. They're not defined. It's very much square peg, round hole, round peg, square hole. All right. So let's dive into the statute. Okay, this was changed in 2015 because the Tennessee Supreme Court in Snodgrass, and Ann will give you a little bit more of a rundown on Snodgrass later, is a 2009 Supreme Court of Tennessee decision that was less than brilliant. Okay? Essentially, the Supreme Court of Tennessee hijacked and jacked up the law on appreciation of separate property for 6 years until some lawyers got together and the TBA lobbyist, I'm assuming, fixed it. All right? So look at page 2 of the materials, and I started on a quote regarding separate property. In determining appreciation for purposes of this subdivision, the court shall utilize any reasonable method of accounting to attribute post-marital appreciation to the value of premarital benefits. Now, you would think there should be a period right there. Nah, not if it's the state legislature. Let's make the sentence more complicated than it needs to be by adding some commas. All right, even though contributions have been made to the account or accounts during the marriage, and even though the contributions have appreciated in value during the marriage, provided, however, okay, no period. Let's just add a whole other conjunctive on here. All right, the contributions made during the marriage, if made as a result of employment during the marriage, and the appreciation attributable to these contributions would be marital property. Are you kidding? Are you kidding? All right. So the key part of this sentence, which is a disaster, all right, is very simple. And I want you to put your red pen on it. The court shall utilize any reasonable method of accounting. All right. So what that means is you get to make this up as forensic accountants. Think about your cost accounting courses, okay? I remember my cost accounting professor who was brilliant and wonderful and smart and patient at the University of Alabama. Roll Tide. But he would say, and I never forgot this, even though it's been decades of scotch between then and now, you tell me what you want the item to cost, and we'll give you a cost accounting method to get there. Okay? Well, what we're talking about is cost accounting, right? Because when we start a marriage and one party has assets, say in a mutual fund, whether it's in retirement or not, okay? There are dollars and there are shares. All right, are we counting shares Are we counting dollars? Statute doesn't say. All right. So what you're able to do is go in there and figure out what makes the most sense for your client and advocate. You say, well, wait a second, we're independent. All right. So you need to think about what are accurate ways to calculate what's marital and what's separate in terms of the appreciation in that account. Okay. Do you do shares? Do you do dividends? Do you track every little thing over the length of the marriage? And part of that depends on, do you have the documents? You got to figure that out. All right. But assuming, for purposes of discussion, you have all the documents, you've got all the statements, you know what the dividends were for each mutual fund. And let's say there's only 3 mutual funds. Not 20 like you might see in the real world, but for purposes of discussion, there's only 3. Well, in theory, on those 3 accounts, you can go back in time and research what dividends were issued and whether or not this account reinvested those dividends of shares of mutual funds. Now, or do you just go straight up dollars and deal with it that way? All right. The point is, your first assignment from your lawyer should be, tell me what our options are. From there, you try to figure out what makes best sense for your client, but you may not have that discussion with your client. And maybe the lawyer's job. Depends on your relationship with the client's lawyer. Now, that being said, remember your test is the method reasonable? All right. Now, in the real world, where I live, they know me there. Any reasonable method that you put, that one forensic accountant puts together, likely may not even be challenged. So if you could get your forensic accountant early, get the forensic accountant to issue a report using any reasonable method, you got a good shot at going to mediation and settling that case without having an opposing expert. How do I know that? 25 years of experience. I've done it. All right. So, even before 2009, this was the law, which is kind of fun. So, as you go through the cases, keep in mind that from 2009 to 2015, those cases are less than trustworthy, okay? Because they applied law that didn't exist. But all the 2015 statute did, the change was to fix the problem.